I'll start. I just wanted to say, as head of Kingsley Napley's public law team, I'm really delighted to welcome you all here today to Kingsley Napley. We're delighted to be helping the Human Rights Lawyers Association bring together all of you, the community of lawyers who work to protect human rights in your different ways, through the vital work of campaigning and challenging governments, but also through the work of promoting respect for human rights within our institution. Today's event celebrates three very important anniversaries: the 20th anniversary of the Human Rights Lawyers Association, the 70th anniversary of the European Convention of Human Rights coming into force, and the 75th anniversary of the Universal Declaration of Human Rights. So that's fantastic that we've come quite so far and that these instruments are still in place. But it's a timely and important event, today's event. We sadly live in a time when it's particularly pressing that we work our hardest to ensure observance of basic human rights and trust in the rule of law, both in domestic and in international contexts. We're particularly lucky this afternoon to be able to listen to a truly inspiring lineup of speakers and to hear their important views on the next stages in the journey. And I think an enormous well done to the HRLA for organising this event and such impressive speakers who are going to be introduced by the chairs in due course. Before we come on to that, I'm afraid I've got to delay you with a couple of housekeeping points. The first is we're not expecting to have a fire alarm today. The fire exit is right behind you at the back of the room if an alarm sounds. In terms of toilets and facilities, you'll find them over on behind the screen on my left. And finally, we're due to finish at 7 o'clock tonight, but please do join us for a drink in the reception area outside. I should mention also, do put your phones on silent and do note that the event is being recorded. So if you ask any questions, that they will be recorded. Now over to Sharab.
Hi, good afternoon, everyone. Thank you so much. Thank you, Sophie. I'm not going to speak for long at all. My name is Shoaib M. Khan. I'm Vice Chair of the HRLA. Thank you, everyone, for being here. Firstly, a huge thanks to Kingsley Napley, of course, for having us and hosting us, and without whom literally we would not be here. So of course, it's amazing that they've done this for us. And then to everyone who's here, usually, we get to see distinguished human rights, dear friends, usually just on the panel, but today it's amazing we have them at audience, so many watching at home or watching us online as well. So it's amazing how people have responded to this. So thank you. Finally, to the speakers, of course, an absolutely brilliant, stellar panel, really. It's amazing that they all, as usual, for most of them, as always, we just sent them an email, a message, something, and they're just right there, dropping everything that they have and just turning up for us. So that is amazing. I know it's never easy planning for or preparing for events like this, but it is always made about, twice, thrice, 10 times as hard when I'm the one organizing. So, so true thanks and apologies maybe to all the speakers today for, for their resilience and determination, determined to be here despite what they've been through with me over the past few weeks. So thank you so much, everyone. And I think that's it. So I will just introduce our wonderful chair for the first panel today. Jessica Seymour Casey basically needs no introduction, but I'll say a few words anyway. She's a barrister at Matrix, where she is a founder member. She is one of the country's leading specialists in public EU human rights law. She's worked at the European Commission Environment Directorate in Brussels, at the ECHR, and in the Human Rights Ombudsman Office in Sarajevo. She's the original author, now consultant editor of Sweetan Maxwell's Human Rights Practice. In 2016, she was the UK nominee to be the UK judge at the ECHR. She's also a visiting professor at LSE and Goldsmiths. So we're absolutely delighted she accepted our invitation to be here. So I'll just hand over to Jessica now. Thank you so much.
Thank you. Thank you very much. I don't know whether this is working, is it? Can everybody hear? Yes, good. Well, thank you so much, Shoaib. It's a real pleasure to be here and fantastic to see so many old friends and faces here today. So I've been asked to present or introduce the first panel. It's a mystery panel. It has no title, so we will see what it involves. We have some amazing speakers, 4 amazing speakers. You'll no doubt know them well. Jacqueline McKenzie, who's a partner and head of immigration and asylum law at Lee Day. She was on the independent advisory group that delivered the Windrush Lessons Learned review, and she represents hundreds of people affected by Windrush. She was, during a sabbatical period, chief executive of Female Prisoners Welfare Association, Hibiscus Initiatives, and she is founder of the Center for Migration Advice and Research and has won many, many awards for her work. Some of you may remember her article written in The Guardian on the 8th of August this year, after she was subject to a bit of a hit job, a political hit job for her legal work. And obviously that's something very important that we may want to discuss today, the right of lawyers to carry on with their work without being attacked by politicians. And we then have my colleague, both at LSE and Matrix, Professor Conor Gearty, who needs no introduction. He's Professor of Human Rights Law at the LSE since 2002. He became a fellow at Emmanuel Cambridge between 83 and 90, and then moved to the law school at King's, which he left as a professor. And he was director of LSE's Center for the Study of Human Rights from 2002 to 2009. And in 2012 became the director of LSE's Institute of Public Affairs. And then we have Parosha Chandran, who I know from British Institute of Human Rights days, way back. She is Professor of Practice in Modern Slavery at King's College London, is a human rights barrister at One Pump Court, and has received many honors for her work, including the Trafficking in Persons Hero Award 2015, which she received from John Kerry in Washington for her unparalleled achievements in providing legal services to survivors of modern slavery. And she is Senior Legal Advisor to the UK Parliament's Modern Slavery Project and General Editor of the leading textbook, Human Trafficking and Modern Day Slavery in the UK. And finally, last but not least, we have Andrew Cutting, who's responsible for communications at the Council of Europe in Brussels, in the Brussels office, and he is part of the main communications team for the European Union, the UK, Ireland, and the Benelux countries, and Turkey. And he covers also the ECHR system in close coordination with colleagues at the European Court of Human Rights. And it will be very interesting to hear from him in relation to the issues that we all know are going on at the moment, as between the UK and the European Court. So I actually don't know who is speaking first because we haven't, but if we do it in order of introduction, does that suit everyone?
Oh dear, I was hoping not. Do we need mics and things?
Why don't you take that mic? Does that work?
Good afternoon. Yes, I think it does. Is it? Yeah. Well, thank you to our chair, Jessica Seymour KC, and my colleagues on the panel. And thank you to the hosts, the Human Rights Lawyers Association, for inviting me, not just to speak, but to join you in celebrating your 20th anniversary, and particularly as we mark the 75th and the 70th anniversaries of the Universal Declaration of Human Rights and the coming into force of the European Convention of Human Rights, respectively. I did ask yesterday, because I'm so organised, what I'm supposed to be speaking about. I was told anything, which can be quite dangerous. Well, anything within the context of why we're here. So I thought I'd use the time allotted to me, since I've become the ultimate dartboard for the government and right-wing commentators, as recent as today with the announcement of the increase in the net migration figures, to live up to my reputation and be political, but sufficiently well-behaved so as to not compromise our hosts. So we mark these anniversaries at a time when the rights these international agreements convey upon us as citizens and across our societies are undeniably under attack. These attacks manifest themselves in the targeting of individuals and institutions and organizations with the sole purpose of undermining the roles of those who act to protect rights when these are infringed. We see these attacks bolstered by executive decision-making and legislative action at a time when we see our great institutions of the state seemingly acting in a problematic way, to the extent that the very prerequisite for the protection of our rights, a functioning democracy, is becoming questionable. And if we mix this realpolitik with the sections of the media and those nefarious, well-resourced organizations who all set out to undermine the rights of some of society's most marginalized communities, and I place asylum seekers and refugees in this context to center this within my work, we cannot say that we have a functioning democracy in much other than name and instruments, those instruments which imply that we have that. Those of us in this room will be familiar with the principles behind the ECHR and the Universal Declaration. And in the case of the former, the words of Guido Raimondi, a former president of the Court of Human Rights, should be borne to mind. And he said, the European system of protection of human rights with its court would be inconceivable untied from democracy. In fact, we have a bound that is not only regional or geographic, and a state cannot be party of the European Convention on Human Rights if it is not a member of the Council of Europe, and it cannot be a member state of the Council of Europe if it does not respect pluralistic democracy, the rule of law, and human rights. So a non-democratic state could not participate in the ECHR system. The protection of democracy goes hand in hand with the protection of rights. Some of you may well take issue at the suggestion that we do not have a functioning pluralistic democracy and be critical of thinkers, especially in the global South, who say that these forms of democracy throw up systems with marginally distinguishable political elites and parties who dominate the perception of a democracy, as we see in the UK and the US. And in many countries, including those in the global South who follow this style of democracy, in the vernacular known as the Westminster style democracy. Of course, this does not mean that rights are better protected elsewhere, but we have come to rely on our systems and the supposed superiority of these systems as a safety net for both the regard and protection of the rights that we have secured, not just in domestic law, not just in being able to agitate and advocate for rights as individuals and organizations, but by being part of a global system of those rights, be it in Europe or wider afield, as in our membership, or us rather being a signatory to the Universal Declaration of Human Rights. So these rights that our ancestors and some of our contemporaries of yesterday, and despite the ructions that we've seen or we're seeing now around the world, fought for to keep us safe, we're seeing this attack on our ability to seek redress for the many infringements. And we're now seeing quite a dangerous assault from politicians, and where these politicians are mighty by virtues of majorities, parliamentary democracies, and this looks likely to be the case for some time. We need to be very worried about how we safeguard those rights and how we as lawyers, activists or otherwise, work to protect those rights. Most of us would have been alarmed when just minutes after the decision in the 6 appeals against the Secretary of State for the Home Department in what we refer to as the Rwanda cases last week, heard the then Secretary of State, Suella Braverman, and the current Prime Minister, Rishi Sunak, both indicating that they'd implement emergency legislation to display or to disapply, can't usually read my own handwriting, now I can't read my own typing, to disapply the Human Rights Act to be able to send people to Rwanda. And we took heed from the words of Yasmin Ahmed, the head of Human Rights Watch, when she said, and it was quoted in The Guardian last week too, Rishi Sunak's government must know that even scrapping the Human Rights Act will not prevent it from facing significant legal barriers to its Rwanda policy. But what we're seeking is the UK moving towards a place where the government feels it can undermine the integrity of the judiciary, undermine or scrap human rights laws that don't serve its current political agenda, and create new laws that do so. This is a dangerous place to find ourselves in. This can start to look very much like authoritarianism. And she continued, this approach not only discredits and undermines our ability to hold other human rights violators to account on the international stage, but it creates a model of governance that puts political ideology over a state's legal obligation to uphold basic human rights that were put into law to protect us all. Once you attack, discredit, and tear up these laws and frameworks, it would be almost impossible to put them back together. And of course, the UK government has not ruled out withdrawing from the European Convention on Human Rights to allow easier implementation of its measures on a number of things, but including to be able to remove asylum seekers to Rwanda. And we expect more of this rhetoric, as just today, journalists have been speculating about appointments that have been made to Conservative Central Headquarters, implying that that possibly means there'll be an election earlier rather than later into the new year. We expect more attacks on you and on me. We expect more attacks on the most vulnerable people in our society, asylum seekers and refugees, in particular, those coming to the UK in small boats, particularly as the election looms. And we will see very little rebuttal from anyone other than ourselves. I was very disheartened to learn that senior Labour politicians, for instance, felt that though the attack on me was because of the work that I was doing with Labour on a white paper on possible legislation on anti-racism measures, felt that they couldn't possibly comment publicly because the story had at its heart immigration. And when they realized that the support from our profession and the public was overwhelming, and approached to find out what they could do some 3 weeks after the 5th of August attack, it was too late. And in recent months, ECHR withdrawal has come up in relation to the Illegal Migration Act. It was on the table during the era of the Bill of Rights, seeking to replace the Human Rights Act with that, and features heavily in the Northern Ireland Protocol deal with the implications for the Good Friday Agreement. So, whether we look left or right, our rights will be under attack, in my opinion. The reasons underpinning these attacks might be different, but the attacks will escalate. We have a duty of lawyers to go further, and I know most of you do. Yes, of course, we know that Rwanda has a poor track record on human rights. Much of the world does right now, which is why it is important for us to safeguard what we have won so far with the conventions and the declarations. But when you look at a lot of the reporting on Rwanda, even from lawyers, the racism that underpinned it, here was not just an unsafe country, but an unsafe African, Black-led, corrupt country. And we couldn't see that. That is not our fault that the law or that case narrowed down significantly to whether that country was safe or not, which was always something that I regretted, because what if the government came up tomorrow with a plan for Grenada or St. Lucia or Barbados, which nobody ever argues are unsafe, then what's going to be the campaign then? But nevertheless, the law took us down that very, very narrow road, but the reporting of it, in my mind, was very, very problematic, even though we know what the problems are in Rwanda. So we have a duty, even when we fight and win cases, to think more broadly about the implications of the politics behind these cases and how we react to that. We know too, and I'm going to finish now before I get a note from Jessica, because I'm sure it's time. We know too that the UK does not have, and this is a classic example of where I say our role isn't just simply to do the law, because we know that the UK does not have a significant crisis with asylum seekers. If the tens of thousands we get annually, or rather we get tens of thousands annually, and that pales into considerable significance when you look at the global picture of 120 million people displaced. Trinidad and Tobago, with a population of just over 1 million people, has taken in 200,000 people from Venezuela, forced out because of the economic crisis there caused by the US. There are 1 million people of the Rohingya group in Bangladesh. Poland took in more than 2 million people from Ukraine. And I cite those examples because they're very, very contemporary ones. The countries who struggle with the issues of settling asylum seekers and refugees are not those rich countries in the global south, but much poorer countries, or certainly poor structurally, as they're quite rich often in resources, which are misapplied and stolen and so forth, but those countries in the global south. We celebrate the conventions and declarations that cross boundaries and nations, but in my mind, we can only do that effectively if we use our knowledge as lawyers to help educate on the basis of the information we have and the data we are privy to, and to help change hearts and minds. So whilst we're drafting our lofty skeletons and making eloquent submissions, we do have a duty to be part, I think, of the struggle. We can dispel the myths that some people have more rights than others by doing that. We can dispel the myth that your rights are being trampled in favor of others. We can promote the benefits of being in the ECHR and the UDHR, but not just in rooms like this one. There's no room for complacency. The UK and much of the world is in a very bad place. If you're not already an activist lawyer, and I'm sure many of you are, I urge you to think of becoming one.
I don't believe you only found this out yesterday.
Yeah, today.
I'm just a technical adjustment. I'm here because the further away from the chair you are, the harder it is to stop you. I've learned, I'm not saying it, I've learned from English culture over many years, they're very polite. So I exploit the politeness. But Jess, I give you permission to shout at me. There are not detailed notes. I want to check something. Where are we? Kingsley Napoli? I spent 10 minutes of a very short speech at a big event in October, attacking the wrong law firm. I got it completely wrong. I attacked them. It wasn't even them. So look, you're wonderful. Are you from Kingsley Napoli? Yeah. You're wonderful to give us this slightly small room. Job done. Right. Very good. And Sean, thank you for setting this up. What an amazing organizer you are, I have to say. Congratulations. And I just want to notice Jonathan Cooper. He was one of my closest friends. And I regarded this very much as his baby. And it's an amazing thing. It's still going after 20 years. And now, the rest of this is actually a bit gloomy. It's a bit gloomy. But I really think we're building on what we've just heard in that brilliant talk, really brilliant talk, drawing attention to some of the key essentials, which I'll draw out. I think it's really not at all a given that this language of human rights will survive. I wrote a book 18 years ago called Can Human Rights Survive? I think it's not, and I want to explain why. I want to try and shake myself and yourselves up a little bit. One of the things we've sometimes done as a community is be too quickly too cross and too quickly too angry. But the levels of change that are happening around us are frightening. They really are. And I think we need to acknowledge that the changes may not be to our liking and they may continue. Let's start with the most important human rights person in the world today is Karim Khan, in my opinion. We have got a pretty amazing situation at the moment where this country is supporting what look to be the commission of very serious war crimes in another jurisdiction. I say this country supporting serious war crimes, not because I want to defend Hamas, whose conduct on the 7th of October and thereafter has also involved the commission of serious offenses, but it's not been supported, just as the actions of the Russians were not supported, and just as Mr. Putin was indicted. I'm not interested in that which we opposed, because that can fit with our human rights beliefs. I'm extremely interested and concerned by our support for what looks very much to be the commission of war crimes. I find it hard to believe, frankly, having gone into this a bit for a piece I published today, to be problematic. I really do. I think the definitions also embrace, to some extent, crimes against humanity. And I'm bound to say, reluctant though I am to escalate and inflate language in a disturbing way, the clear messages that have emerged from senior political and military figures in Israel, messages which have dehumanized Palestinians and explicitly indicated an intention by people in authority to turn Gaza into a living hell, and messages that have, from the president, made clear the belief that the entire population is responsible for the actions of Hamas, come quite close, he said carefully, to the greatest and most awful crime of all. Now, as a result of a ruling by the International Court, it is clear beyond peradventure and cannot be challenged that the prosecutor and his team have jurisdiction to investigate what is going on in Gaza. Israel are, of course, not members of the international criminal system, but Palestine are and have been accepted as such. So the jurisdictional cards, as far as I can tell, cannot be played. The extraordinary openness about the attacks and their nature and the way in which they patently engage war crimes and other crimes as defined in the Rome Charter make it difficult to avoid investigating. And since the Rome thing is mainly concerned with command, the actions of the authorities in Israel, military and political, in explicitly linking themselves to conduct which falls within the categories of war crimes or crimes against humanity, makes it very difficult not to find the trail of responsibility. The normal war crimes investigation involves some dreadful person who emerges out of some kind of hiding, who was previously some sort of warlord, and who says that none of it, he knew none of it, never occurred to him. He was reading a book, or it's not our lot. That's not available. So Karim Khan, in my opinion, is somebody who has a very big responsibility. Follow the law. International law is no longer the plaything of global Northwestern powers. The United States of America cannot control it, so far as I know. It is not their creature. The International Criminal Court has not fallen apart. New countries have joined. The old insult about it being used only to prosecute Africans was not an insult that was shared by many Africans whose lives had been made oppressive by the people finally brought to book before the International Criminal Court. This court determines whether rules operate in the international system or not. So I think it's a singularly important moment. We're lucky to have Andrew here. I may be out of date in my knowledge. Correct me if I am not, if I am. My understanding is that Israel have enjoyed since 1959 observer status at the Parliamentary Assembly of the Council of Europe. I may be wrong. If you look into the criteria to be rendered, to be given the status of an observer, it requires a commitment to democracy, the rule of law, and human rights, as you'd imagine. Not only are Israel able to enjoy observer status at the Parliamentary Assembly of the Council of Europe, they have chosen to join some conventions where specific arrangements have been made to allow. It will come as no surprise to any of you that they have not chosen nor availed of any opportunity that was given them, which has not been given them, to sign up to the European Convention on Human Rights and Fundamental Freedoms. I've been waging a futile campaign for some time, which has been to give Israel the opportunity to join this convention, to join properly the culture to which they feel committed. Aside from the football and the music and the occasional conventions, why not join? We all know the answer. We all know the answer. So I think there's a huge, real challenge, not a notional challenge, to the international criminal system and to the Council of Europe. It's all very well to lament past wrong when it's safely over. What about doing something when we can have influence? What about the European Union, which seems incapable of engaging any of its economic leverage? The saddest thing about Labour's current position is that they explain it by saying we have to behave as though we were in power. It seems to be acknowledged that the appropriate way for a British government to act is to actually permit international crimes to take place because you approve of the people doing it. It's incredible. What's the wider background? Alluded to again just now, as we heard. There is, and this is a little bit of the evidence already given, there's a change going on which is bigger than usual. I'll explain why I think it's going on in a minute. The Dutch, so far as I know, though I have no information, have voted strongly of the right. A man whom we thought was so dangerous he couldn't be let out of the country is the most popular politician in the Netherlands. The Argentinians have just literally voted somebody who is clearly mentally disturbed into the leadership, knowing he is mentally disturbed. The United States has now got a potential president returning to office who calls his political opponents vermin, in language which deliberately, in my opinion, evokes a time past. We wait in horror, I wait in horror, for the outcomes of the forthcoming European elections. We've seen success in Poland, and hats off to old Tusk, but we haven't seen success many places. We've seen Hungary with its deliberate disavowal of what you all and we all hold dear, triumphantly re-elect George Soros, not George, the other guy, the awful guy. What's going on? Here's my opinion, what's going on. That it's big, the big cause is climate. It's forcing life to change for people. It's causing horrific crisis among Global South and others. And linked to that is the final failure of the capitalist system. We're always going on and having conferences in the left about how capitalism is about to fail. I think capitalism has now failed. When you have a minister for finance in Argentina who's running a 140% inflation rate, running against a madman, I almost feel I would choose the madman myself, self-defined madman. So I think we've got huge problems which underpin the changing of attitudes to human rights. We see it in the reaction to the Rwanda case. Those of you with long memories will recall Theresa May's efforts to remove suspected terrorists from the jurisdiction. They always worked within the bounds of the plausible in terms of law. She spent a lot of time negotiating with Jordan to try and get them to have a plausible way of trying the individuals they wanted removed from the United Kingdom. There was never a question of ignoring court orders. How long will it be before we simply ignore orders? There was the forced displacement of people in the United States, Andrew Jackson, Native Americans. It's the Supreme Court's decision, let them enforce it. How far away is such a statement? How far away? The government seems to have, in a way that will please first-year students of constitutional law, announced they're going to legislate to make Rwanda safe. We could add an amendment, legislate to make sure that the earth is flat, and see if we can persuade them to pass that at the same time. That is only one step short of explicit refusal to accept court hearings. We've heard already about the extent to which courts are being set aside, anticipated. Legislation is deliberately infringing rights. This is off a piece of a change of circumstance. And the enemy without is joined by the enemy within. I must be running out of time, but I'll begin to wind up now. Beginning to wind up and winding up are quite different things in my own imagination. This where the distance from the chair is quite good, actually. No, this is seriously the last point, because it's about this shocking exposure of lawyers. And our hearts go out to you in solidarity with what you've had to go through. But what's going on here is this, in my opinion. Society erected a set of benchmarks for itself some years ago, and it called them laws. The one we're most familiar with is the Human Rights Act. And it was widely supported. And for many years, through the noughties and right into the time of, I see Dominic Grievous here, Dominic's time, there was an acknowledgement that there was a difference between disliking a case and accepting the institutions from which the dislikable case emerged. That's changed. There is no longer a commitment in our culture to that which caused the laws that we see to have been enacted. And this applies also to welfare, to disability, to pensions. There's a new ugly brutality in the air. What are we going to do with it? There's the austerity drive resurrected, and the courts, confronted by the crisis of what to do about it, produce some stuff about margins of appreciation and try and escape the problem that they're colluding in the impoverishment of people. And impoverishment people desire, the public want. There's a new, even greater than usual brutality in the field of criminalism, in criminal law. What are we going to do? It's law that holds us to the word made by people who've left the stage. And they have been replaced by people who want to renege on the deal. They haven't yet got to the point where they'll pass a Public Safety Act or they'll take upon themselves the power to set aside law at will. But it's not far away. And we need to work out what to do about it. Thank you.
Thank you, Conor. Unsurprisingly, Conor raised the most difficult and challenging issue of the moment. I think if we get to a discussion, obviously there are very strong emotions around this issue, and it's a very, very difficult issue to deal with. So I think we'll bear that in mind as we move on.
Well, it's very nice to be here. Thank you, Shoaib, Human Rights Lawyers Association, Kingsley Napley, Jessica, many friends and colleagues in the room. So I'm Parosha Chandran, been practicing in the field of human trafficking, modern slavery for the last 20 years this year. And we're here to celebrate the Universal Declaration on Human Rights. So I thought I'd just take a few steps back because this is the 30th year since I joined the field of human rights. I studied in Strasbourg at a place called the International Institute of Human Rights, which was set up by René Cassin, who along with Eleanor Roosevelt drafted the Universal Declaration on Human Rights, and they won the Nobel Peace Prize. And with his share of the money, he set up an educational institute in his hometown. And in 1993, 30 years ago, I went and studied there a 1-month residential course on human rights, taught by the world's leading experts. We learned about the UN system, the Inter-American system, the European system, the African system. And every afternoon, we took a course on international humanitarian law. Why? The war in Bosnia was raging. All attention was to be given to understanding where rights could lie and where protection could be found. And that's where I found myself. I found my passion, and here I am 30 years later, privileged to speak to all of you. So 10 years after that, we had the Palermo Protocol, which is the human trafficking instrument, enter into force. It's 2000, but it entered into force in 2003. And that modernized some of the language that was in the Universal Declaration on Human Rights. So I'm going to just try and take you through a whistle-stop tour of the law on slavery, human trafficking, and take you through a few world cases just for a flavor of where we have been, where we are, and where we need to go. So let's start at the beginning. The Universal Declaration on Human Rights, you know, Article 4, that's the prohibition on slavery and the slave trade. It also prohibited servitude. It didn't prohibit forced labor. But as we know, the Universal Declaration is the mothership of the international human rights regime and the moral, political, and leadership and legal leadership that was needed to create a floor of human rights protection, not a ceiling. and to prevent all the atrocities that happened in the Second World War from ever happening again by having a rights-based instrument that could then be imported, translated, interpreted, and legislated, most importantly, into domestic laws, regional laws, and eradicate as well harmful customs and practices. We then follow that in 1950, of course, with the European Convention on Human Rights, Article 4, which does include a prohibition on forced labor too. And then by 1996, we've got the ICCPR, again, similar language under Article 8. By 1969, we've got the American Convention on Human Rights, Article 6, which talks about the same language as well, freedom from slavery, servitude, prohibition of the slave trade. It talks about involuntary servitude, which is kind of quizzical. How could somebody volunteer into servitude? But these things are very interesting in my area of law, because we've seen very excellent developments in the court's interpretation of what these things mean and how we can apply them in practice, and ultimately how we can protect people. And then we've got the African Charter on Human Rights, which has got very important language. Article 5, this is of 1981, talks about the right to respect of the dignity inherent in a human being and the recognition of his legal status, and all forms of exploitation and degradation of man, particularly slavery, slave trade, torture, cruel, inhuman, and degrading treatment, and punishment and treatment shall be prohibited, which is interesting because it amalgamates what we know as Articles 2 and 3 of the European Convention on Human Rights and other treaties. But all of this language, where does it come from? It comes from the Universal Declaration on Human Rights, Article 4, and the need to have enforceable treaty rights that can give individual protection when states get it wrong. Of course, some of the treaties have individual rights to petition, others don't. But I'm just now going to tell you about a few short cases in the short minutes I have. Hadija Mani. Hadija Mani, she was a girl who at the age of 12 was sold to a master who was 46 in the country of Niger. This was a practice, a customary practice by which this happened, called wahia. She was allowed to be sold as a servant and as a concubine, and was termed under that customary practice as the fifth wife. What does that mean? It means there is no legal status for her as a human being or any protection, because the law of Islam was protecting 4 wives, and she was outside of that protection regime. She was raped at the age of 12. She was kept for 9 years in that cultural tradition and practice. She was a daughter of 2 slaves herself. Eventually, because of the norms in Niger requiring slave owners to release their slaves, she was given a certificate of emancipation by her master, but he didn't want her to be free. And when she tried to leave, he didn't allow her to, so she escaped. She went to her mother. She then eventually married legally for the first time a man she fell in love with. Having been in this abusive marriage, she had had 4 children, 2 had survived, and terrible child abuse during that time. When she took that step of self-determination, what did the former master do? He brought a criminal complaint of bigamy against her. She was found guilty. She was imprisoned for 6 months, and she was fined. And it took lawyers to bring a case against the former master for slavery. It was the first case that was brought under the African Charter language that I just mentioned to you. You might have been thinking, what was all that relevant about? There you go. And the court looked very closely at international law. It looked at the Kunarak decision in the ICTY and the conditions of slavery. And it found that in the Barcelona Traction case, there had also been a requirement for all states to protect against slavery as an erga omnes obligation. And it found that she had been kept for 9 years in a condition of slavery, that this was a cultural practice which had to be abolished, and she was compensated. It's a very important case because it then created a whole cultural movement of change that allowed the real recognition of the inferiority of girls and women that had been an accepted norm and had been inbuilt into community lifestyles to start being unpacked. Now let's jump over to the inter-American system. There's an important case. I'm not going to tell you much about it, but I'd like you to look at it if you're interested. It's the Hacienda Brasil Verde case, which involved indigenous Brazilian men in particular being taken onto plantation farms and kept in the most extreme conditions of harmful labor. And this was a vulnerable group of persons who had no other way of working anyway. And so this was a case where the Inter-American Court of Human Rights found direct violations of slavery against Brazil, which again can start to show where cultural practices need to change and where responsibility lies. Now we'll go to Russia and we'll think about the Rantsev and Cyprus and Russia case in the European Court of Human Rights in 2010. So we saw that the Universal Declaration included the prohibition of slavery, servitude, and the slave trade. Then we see some movement that includes forced labor in later treaties. But what about trafficking, human trafficking? That's nowhere to be seen. So what role does it have in this international system? The European Court of Human Rights in 2010, in the case of Rantsev, pronounced that the prohibited norms under Article 4 of the ECHR include a prohibition on human trafficking, because human trafficking is the modern form of the old slave trade. So what's the difference in definitions? Human trafficking can be said to be the manner by which a person is brought into a condition of exploitation, because it requires forensically one of 5 acts to be proved: recruitment, receipt, harbor, transportation, or transfer of a person for the purpose of exploitation. And then the exploitation list is open, not closed. It includes slavery, servitude, forced labor, the ones we know about, removal of organs. Jeffrey Nice is here, who dealt with the China Tribunal here in London in respect of the forced, the murders, frankly, of people in China who are in detention for their organs on a order to kill policy, really. And also sexual exploitation. The tension was then, how do we work out where consent is relevant? Because what if someone agreed to go to a different place for a job that might fall under one of those forms of labor? And what if somebody was deceived if they went? What if they were coerced? What if they were vulnerable and they were then trapped? Well, the best part of then the language comes when we see Rantsev, when we see the case of Chowdhury against Greece, which is an important case of 2017 in the ECHR system, that the language of Palermo is always to be applied, which is when any of those traps are used, coercion, deception, threat, force, abduction, abuse of a position of vulnerability or of power, consent is rendered irrelevant because the person was never freely giving their will to the condition that they were later placed into. And then finally, to wrap up, non-punishment. That's an area that I've worked very hard on for many, many years, which led to the judgment in the European Court of Human Rights in 2021 of VCL and AN against the United Kingdom. AN against the UK was my case, and it took a long time to reach there. Non-punishment is about the obligation on states not to prosecute or punish someone who commits an offence as a direct consequence of their trafficking. in this scenario, it related to a child from Vietnam who had been trafficked. He was recruited for the purpose of exploitation for cannabis cultivation. He was found in premises in the UK where the CPS's own admission was that the drugs were between 500,000 and £1 million worth in value. He was there sleeping on a sheet on a concrete floor as a boy when he was found. He had nothing to do with those hallmarks of organised crime. The traffickers got away and he got arrested, charged, convicted and imprisoned. And it took 9 years for me to get that judgment, having worked on that case right from the beginning. In 2011, I had to wait until 2021. So actually it was 10 years. And that's something I want to leave you with. And sorry, just to tell you, that became the unanimous judgment of the court. It's the first global judgment on the application of the non-punishment principle, and is now being very carefully considered in a number of countries, including the US, which has always been incredibly resistant to giving anything in terms of protection to anyone who's not a victim of sex trafficking. And so now looking at other forms of exploitation. So where we are now is that modern slavery still grows, it develops, traffickers are ahead of law enforcement, and states are slower than lawyers. So the importance is to recognize how law really is quite transformative in this field. And I have felt always what a privilege it is to have those NGOs on the ground who are working so hard to protect, to save, to heal. And there is always a role for lawyers to litigate. Thank you.
Thank you. Hello, everybody. Very pleased to be here. Thank you, Shoaib, in particular, for inviting me and for your excellent organisation of this wonderful event with so many top-level speakers. My imposter complex has kind of gone crazy over the last couple of weeks, but I know that the British judge at the court, Tim Maika, was very much hoping to be here today and to speak to you all. Unfortunately, he couldn't make it in the end, so I'm afraid you'll just have to put up with a rather less distinguished representative of the Strasbourg apparatus, but hopefully I can give a slightly different perspective, given that I'm a communicator rather than a lawyer as such. So I was just hoping to speak to you a bit today about some of the challenges that we face in communicating the ECHR system in particular, and some of the methods we're adopting to try and tackle some of those challenges, and I'd be very happy to answer any questions anybody may have afterwards. So very quickly, what I do, I'm not the spokesperson for the court. I work for the Council of Europe, which is obviously the mothership for the court. I joined the council 20 years ago now in 2003. So I think I'm pretty much the longest serving member of the council's press team. In the meantime, I've moved to the Brussels office. Obviously, that's a very important European media centre. So it makes sense for us to have somebody on the ground there. And the job has also changed over the years. So I now get involved in social media and events and publications and building relations with stakeholders and all kinds of different things in addition to traditional media work. My primary focus is Brussels, but I cover the UK, obviously, as part of my job. And I have to be honest, that takes up rather a lot of my time, certainly in the past few weeks. It's been possibly busier than at any stage I can remember. But I should say that calls for the UK to leave the convention have from certain quarters have been one of the kind of recurring themes of my time at the Council of Europe, going back as far as I can remember, so almost 20 years now. I've worked very closely with colleagues at the court's own press office over the years and worked on the ECHR system, whether that's concerns the judgments and decisions from the court, also the execution of judgments. I coordinate our work on the execution process. And more recently, I've been managing a project trying to highlight the positive impact of the convention system, which I will come on to. So I also, given my background, have a acceptable knowledge, I guess, of the UK political and media landscape, as well as European affairs, and I try and marry those things together in some of the work that I do. So talking about some of the challenges that we face, well, obviously the court is, being a court, quite limited in what it can say on occasion. It comes up with its judgments and decisions, and it produces rather long and detailed press releases that hopefully you'll be familiar with, which are all approved by lawyers, and which doesn't necessarily fit the modern communications environment as such. The court doesn't get involved in controversies or fights in the media, and sometimes it must look as if it just stands back and takes the punches, which are thrown from various different angles with some regularity. It also has a huge workload, as I'm sure you're also aware. There are something like 75,000 cases currently pending at the court. We have limited resources. The Council of Europe as a whole spends in a year roughly what the EU spends in one afternoon. I know they're not directly comparable, and we don't build roads and hospitals, but it gives you an idea that our resources are relatively limited. We also have 46 member states, of course, and we work on a wide range of issues, so not just the convention system, although that is very much the pillar, if you like, of what we do. And so, given these constraints, the Council of Europe does kind of, especially me, I guess, to a certain extent, supplement the communications work that's done by the court together with colleagues in Strasbourg. One of the things that we try and put across to various audiences is that the court and its rulings don't exist in the vacuum. So the court is part of the Council of Europe, obviously, and there is a ministerial body, the Committee of Ministers. We have a parliamentary assembly, which includes many British members of Parliament and members of the House of Lords, although some of them are rather reluctant to make their work in Strasbourg known at times. And we have various different structures representing local and regional authorities, for example, and we have various different monitoring bodies. We have now, alongside the Human Rights Convention, I think we have 224 different conventions, so all legally binding international treaties, and we have different bodies which monitor the extent to which those conventions are put into practice by the member states. Most well known, of course, being the European Court of Human Rights. And we also trying to explain that, because often you read about judgments from the court and they just kind of explode in the media and then disappear, and you may never hear about them again. So there's quite a lot of work to do explaining to people that there is a system in place to make sure that member states actually put those judgments into practice. It often takes some time. It's quite a complicated procedure. Many of my own colleagues, I think, possibly don't grasp exactly how it works. So all of that is quite a communications challenge. There are a number of different misconceptions, should I say, about the court and the convention system that we try and tackle as best we can. I would say in my 20 years at the Council of Europe, one of the biggest of these has been the confusion with the EU and the EU institutions. Although I think for the UK at least, that's become less of a problem in recent years. And I think most people now understand that the UK may well have left the EU, but it certainly hasn't left the Council of Europe or the Human Rights Convention. There is also, I'm talking here from the UK perspective, sometimes I think people have the impression that the court is a foreign court which somehow has it in for the UK and that it practically deals with nothing else. which couldn't be further from the truth, to be honest. As you know, it's an international court, not a foreign court, and UK was very much involved in setting the whole system up in the first place. The UK is one of the most influential, I would say arguably the most influential national representation in Strasbourg. They are very active and very supportive of all of the work that the Council of Europe does. The UK has an excellent, well, a very good record on the very low number of cases that come to Strasbourg, the low number of judgments and the low number of violations, to the extent that I do have some figures here. I won't bore you with figures, but I'll just go through some of them. In 2022, so last year, the court issued 1,163 judgments, of which 4 concerned the United Kingdom, and just 2 of those resulted in violations of the convention. There were 260 applications concerning the UK last year, 255 of which were declared inadmissible or struck out. And I think, as I said, of the 75,000 pending cases, I think something like 140 of them relate to the UK, and almost half of those have a good chance of being declared inadmissible. So the UK makes up a very small proportion of the court's overall workload, and it has a very large influence in how the system functions. We also have recurring questions, for example, about the unelected judges in Strasbourg, which is not true. The judges are elected by members of our Parliamentary Assembly, unlike British judges, I hasten to add, who are not elected. Whether judges should or should not be elected is, of course, another point altogether, but this is routinely thrown at us in certain parts of the media. One other statistic I forgot to mention was that the court receives fewer applications per head of population from the UK than from anywhere else, any of our 46 member states. I think it's something like 0.03 applications per 10,000 inhabitants. And the only countries that come close to that are Ireland and Germany, and they both have at least twice as many applications as the UK. So, as I say, very small workload. So we find that some of the political discourse, and some of what we read in the media is slightly distorted. It's certainly not something that I recognise, but partly the problem there is the nature of the beast. I mean, we all know that the British press is quite has its own characteristics, let's say, which some of my colleagues from the other member states don't quite understand. And the media, obviously, it focuses on conflict. So you're only likely to hear about A, judgments concerning the UK, B, judgments where the UK loses, and C, cases which are brought by relatively unpopular groups, let's say. And those 3 things together mean most people only hear about a very, very small proportion of the cases that the court deals with. And that skews their opinion of the court and the convention system as a whole, obviously. There are, I realise we're quite short of time already. I won't go into some of the misunderstandings, let's say, that have been specifically related to the Rwanda issue over the last few months, but there have been some, and they've kept me quite busy over the last few months. So how do we go about trying to tackle some of these negative perceptions or these misunderstandings around the court? Well, we're trying pretty hard to demonstrate that the convention system is not just about protecting the rights of unpopular groups in society, let's say, but the convention is there for everybody, and it covers all sorts of aspects of life, many different areas of life, and many different countries. So its international importance is something I think that really doesn't come across in the international, in the national debate here in the UK. We do that partially by making more use of social media, which helps us to get around this hurdle of we don't necessarily want the media to decide the whole time which information goes out into the public domain about the work that we do. So social media is one way around that. But the project that I previously mentioned, highlighting the positive impact of the convention on ordinary people's lives, has been a significant focus of our work for more than 5 years now. We have it's centered around a website. I'll give you the URL in case you're interested. It's a very simple one. So it's coe.int/ECHR. And there we have over 200 different cases from all of our member states, covering, they're grouped by 16 different themes, which more or less relate to different articles of the convention. And we try and use a storytelling approach to say, this is a problem that happened. The person, they didn't find what they were looking for in their national legal system, so they ended up bringing a court to Strasbourg. The country involved then implemented the judgment, and this helped not only the individuals involved, but also people more broadly. So the site contains these kind of written case stories, but also we have quotes from applicants. We have some animations to kind of talk people through some of these stories. And also some of the most interesting content is interviews we've put together with applicants and their lawyers, other legal experts from our different member states, to try and help tell these stories. But so that's quite a major project we've been working on for the last 5 years or so, and we've been trying to focus on, rather than engaging on some of the issues that we know are quite controversial and that people don't necessarily relate to so much, we've been highlighting in particular judgments on issues such as violence against women or healthcare or the environment that people don't necessarily know have come from the Strasbourg Court and have brought about really positive changes to legislation and practice and improved people's lives across the whole continent. Alongside that, of course, we still do some of the more traditional media work, which includes some quite dedicated pedantry from people like myself and people like Shoaib, I have to add, who does a marvelous job of chasing journalists down sometimes when they make horrendous mistakes. But we have a very small team, and just in the last 2 or 3 weeks, there have been literally hundreds of articles on the court and the convention just in the UK media, and we can't possibly hope to correct every inaccuracy that we come across. So you have to pick your fights, and you have to know there are certain media that are never going to write anything positive about us. So there's limited value in engaging with them too much unless they make clear factual errors, in which case we try and jump on things as quickly as possible, and we can be quite insistent, although it's quite a time-consuming process, to make sure at least they don't say things which are clearly wrong about us. And the rest of the media we engage with more consistently, I would say, and try and build positive relationships with journalists and different types of opinion formers as well as taking part in events like this, where we speak to individuals and groups about the work that we do and the benefits of the convention system. So very quickly, is it all working? Well, we do what we can with the resources available. I don't think anybody could claim that the convention system lacks visibility, certainly in the UK in recent years, months, weeks. And there have been a number of opinion polls recently which show that amongst the population at large, the level of support for staying within the system, we try not to use the remain and leave terminology, for staying within the system is at or just over 50%, whereas those who want to quit, shall we say, are under 25%. So it's not as gloomy a picture as some people might think, but at the same time, we know that there are some very important challenges ahead, and anything that anyone else can do to help spread the word and promote the positive benefits of the system is always very gratefully acknowledged by us, because in communications terms, there's this phrase called third-party endorsement, which means however much you might say that you're great, it doesn't make such a difference. But if other people say that you're great, that is that is more helpful in convincing people who are perhaps waverers. And it's those people at the end of the day who might make the difference. There we are. Thank you.
Thank you very much. Thank you to all the speakers. I think you ended really where we started, which was, or rather where Jacqueline ended her speech, was that as lawyers at the moment, we have a duty to be part of the struggle and to reach out widely and educate people beyond the legal world. I was going to ask Shoaib whether we had any time for questions, but he's already told me we don't. So we're going to stop there, I think, and move on to the next panel. Thank you again.